So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. I have Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had prelim back in April that got bound upstairs. The transcript's probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well, it takes
trial in 180 days. I didn't have a prelim for 90 some days. I'm trying to argue that.
So you're waiting on your transcripts, correct?
Yeah.
So they come when they come. They have a time period that they're allowed to get those done by, and they're not going to be done till July. And so you really, your attorneys probably advised you that you don't want to proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times to the prosecutor filing bad writs or however, I think I just would always.
Well, I can't argue the merits of that today because I got to wait for motions, and your attorney will file the motions.
So that means I can't have a trial in 180 days. That's correct.
Do you want me to set you for trial now?
Yes.
Your Honor.
Without your, yes, Ms. Teskey.
This is a whole separate probation violation from his new crimes. Like, this is a probation violation for him being terminated from treatment. It has nothing to do with his new crimes.
So the only thing we're here for today is your probation violation. If you want to plead to your probation violation, I'll be more than happy to sentence you on that. On your probation violation, you're actually facing up to, let's see. So in your probation violation, it alleges that you absconded from the Eaton County RAP program. And that requires, is that right, Ms. Teskey?
No, he was terminated from the RAP program.
Right. So that's an automatic prison term. Is that correct, Ms. Teskey?
That is correct, Your Honor.
So the only thing I can do for you today, Mr. McKenzie, because we're only here on the violation of probation, your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted it separate here.
All right, I can set you a trial on this.
Yep. So
Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would say 2 weeks.
2 weeks? All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie?
yes.
Okay.
Can he do that, Your Honor?
Yep. So, I mean, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Miss Adams, I'm looking for about an hour.
Yeah.
Who are you going to call as?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
And discuss that with him. Do you have some witnesses?
Yeah, her name's Tamia Dillard.
Oh, she runs the program.
Yeah.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All right.
She does, and she was who I would be calling for a witness as well.
Okay. Okay. So.
Are you definitely going to call her, Ms. Teskey?
Yes.
So I would not have to subpoena her then?
No.
All right, you okay with that?
Yeah.
All right.
Ms. Anselm, could I speak for a second?
No, I'm looking for a date, so you gotta wait a minute.
Oh,
I'm sorry, what'd you say?
I told him I know what to say. He can't be my lawyer. I can't do this with
Then
him.
you are more than welcome to hire an attorney, but.
I need somebody that's gonna do something.
So, Mr. McKenzie, here's the deal. You ask for court-appointed attorney, you get a court-appointed
I got
attorney.
this back
Listen
off.
to me.
Now
All
listen.
right, you are held in contempt,
Oh my God.
so I'll bring you back next week. Thank you.
Please, give me 2 years of contempt, please. Could you?
You're actually looking at 5 years.
Oh, please don't.
Oh,
Okay.
have a good day.
Bitch.
Oh, like that's the worst thing I've ever been called. I've been called by,
That's the worst thing you've ever done.
no.
Today we are going to step right into a courtroom moment that sets the tone instantly. From the first words exchanged, you can feel the tension tightening as every eye in the room locks onto what's about to unfold. This opening frame doesn't just introduce the case, it pulls you straight into the storm forming beneath the surface, hinting that nothing here will stay simple for long.
Mr. Lamprecht, you're pleading guilty to OWI 3rd, is that correct?
Yes,
Those sunglasses, or are they prescription?
prescription.
Do you see the plea questionnaire waiver of rights form I have in front of me?
I see them, yes.
Did your attorney go over this document with you?
Very briefly.
Well, maybe if you weren't 18 minutes late, you could add more time with your attorney, right?
I forgot my money, I had to turn around.
Maybe you should have been here maybe 20 minutes prior to your hearing to go over this with your attorney, correct?
Correct.
And I do have a copy of it in front of them as well.
Thank you. And the fact that you forgot the money, is it the court's problem?
A little bit, I mean, but.
Oh, I forgot it for you?
No, it's my problem, but it made it your problem.
It did make it
By
my problem. It made
postponing-
it the district attorney's
by
problem. It made it
postponing-
Mr. Keene's problem.
I apologize.
You are putting my calendar behind right away in the morning.
That's why I said it is a little bit your problem.
No, it is my problem
Yeah.
because you made it my
Yeah,
problem.
yes.
Oh, he went over this document with you, correct?
I have to do stuff, and I have a copy.
Yeah. Yep. So he's went over multiple times. You've had Mr. Keene for some time on this case, correct?
Mhm.
Yes?
Yes,
And you've had him for this time when you've been trying to complete the IDIP, correct?
and I have.
Okay. And so, Mr. Keene, this isn't the first time he's talked to you about what it means to plead guilty to an OWI 3rd, correct?
Correct.
And he's went over with you what the state would have to prove, correct?
Yeah.
Correct?
Correct.
And he's went over the maximum penalties and the minimum penalties you could face. Is that correct?
Yeah,
And he's went over the offer with you that has been presented by Mr. Renicky to recommend to the court IDIP guidelines, correct? What the
Yeah.
offer is, correct? Because you know you're doing an IDIP program for benefits, right?
There was a little confusion between my IDIP worker and him about the hours for community
I don't
service.
care about the community service
Okay.
hours.
I'm just saying that
The other stuff, right?
the other stuff, yes.
Okay. And so he's went over certain other things with you, right? Such as your constitutional rights. Did he go over that with you?
Yes,
And did he go over the fact that I don't have to accept the IDIP guidelines if I thought that the facts of the case warranted it, or your history, etc.? Did he go over that with you?
yes, ma'am.
Okay. So it sounds like he did go over all of the information on this plea questionnaire. Is that your signature on the second page?
Yes,
So you are 44 years old. You can read, write, you understand the English language. You have not had any drugs, alcohol, or other medications, and you have not been deemed mentally incompetent, correct?
correct.
So do you understand all of those constitutional rights on that document that's sitting there right in front of you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights? You won't be able to have those rights again. You can't plead guilty and say, you know what, Judge, I changed my mind. I want a jury trial. You know, do you understand that?
Yes,
And so by pleading guilty, those rights are going away. You understand that?
yes,
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I don't allow coffee in here.
I'm sorry.
I only allow water.
Apologize.
Okay. So do you understand that by pleading guilty, you could be deported if you're not a citizen? I have to ask that
Yes,
to everybody. Okay. And do you understand that, again, here, the state would have to prove certain things, that on or around May 28th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. And this would be a third offense. Do you understand what the state would have to prove?
What would they have to prove?
You operated a motor vehicle.
Okay,
You
yeah,
drove, you operated, you
Yeah.
turned a key, you had the keys
Okay.
in the ignition, you did something to operate the motor vehicle.
Okay,
And that you were under the influence of an intoxicant. You understand that?
okay.
Okay. Do you understand they would have to prove that?
Mhm.
Okay. And this is your third offense, third conviction, right? Is that a yes?
Yes,
Okay. And do you understand that upon conviction, you face a fine of not more than $2,000, that excludes court costs and fees, and imprisonment of not less than 45 days, but no more than 1 year in the county jail? Do you understand that?
yes,
Plus that the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA, OWI assessment and driver safety plan and follow through. You understand that? Yes?
yes.
And you should have done that with the IDIP program, so that should be,
It's taken
Covered.
care of.
yes. All right. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes,
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
yes.
Do you have any questions for your attorney or the court before we proceed?
Sorry.
And that's all kinds of fun today.
Damn it.
Alright, guys, now this is where things start shifting. What seems like a routine exchange suddenly sharpens when the testimony hits an unexpected angle. You can almost sense the courtroom freeze for a second as both sides scramble to readjust. It's a moment where small words carry massive weight, and the balance of the case quietly begins to tilt in a direction no one anticipated.
I think that's his way of saying he's not rushing to press the point, Your Honor.
All right. Okay. So, now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
No, I had 0. I had drank in the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce
And yet you blew a .221, allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, it's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay?
apologize.
You're not supposed to be late to court. Okay? You're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance. And now you're here debating.
No, I'm just
Science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a tenth, 2 numerals behind the decimal is a hundredth,
Yep.
3 numerals behind the decimal is 1,000th.
Yep, I know math.
Okay, and 1,000th is 10 times less than 100th.
Well, let's cut that off, okay? You blew a .22 with a PBT.
221.
or 0.221, okay? So let's say you will cut off the 1, because that's what math does. You get to cut off certain things. So you were 0.22. We'll give you the benefit of the doubt. No more with that 1, that thousandth, gone. So you blew a 0.22. But lab came back and said, guess what? We ran his blood, which is more accurate, and it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
But no, if there's 3 numerals, because if it was point.
Mr. Renicky, I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keene? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra thousandth, though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
You want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to ask her questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just so give me the knowledge because I like math.
Now watch closely because this part escalates fast. The witness hesitates, the attorneys lean in, and the atmosphere thickens as a single answer sparks a chain of reactions. You can see confidence waver and strategy collide right in real time. It's one of those moments where the truth doesn't just come out, it shakes the room before anyone can fully process what it means.
5 out of 10. Has he done a good job in the fact that he's looked to see if you had defenses? Because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm just trying to conversate. I'm not trying to argue.
This isn't a conversate time, okay? This
Okay.
isn't a time to conversate.
Okay.
This is a plea and sentencing in which you showed up to court 18 minutes late.
Okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes.
And has he looked at everything and discussed with you everything that he's seen in discovery?
Except for my one question.
All right, because he's not a scientist. But he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keene, you said that's not a defense, correct?
Yeah, and yes, and we have discussed that in basic math and other things along with it extensively.
All right, okay. You have any? No. All right, so based on this, the OWI third, count 1, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed with count 1. A judgment of conviction will be entered today. Mr. Lamprecht, anything you want to add or say to the court?
Nothing that I haven't already.
Well, I mean, what are you doing employment-wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law, I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk. You're putting others at risk. The fact that you blew a .221, had blood alcohol content from blood at 0.19 is serious, especially given
190.
this is where I'm very serious. You blow even a .0000001 with anything with alcohol, .00001, that's a violation to me. You will be immediately terminated off of the monitor. You will immediately report to jail, and you will sit the whole sentence. No good time, no Huber. I do not take, I was near rubbing alcohol. I do not take, I ate bang bang shrimp. I do not take that I ate tiramisu and it was made with real alcohol. Okay, I take no excuse. It is an immediate report, no good time, no Huber. Report to jail immediately. Your DNA is ordered. They will take that. You can request it be expunged through a written letter to the Department of Justice. Mr. Renicky, what am I missing?
I think you've covered it. Thank you.
What it would be is like, he has that fine of 1,900 and some bucks. What the statute allows is, if the court grants it, is to have the amount of the fine reduced by Mr. Lampick providing receipts to the court for the assessment
I'm
and driver's
denying
safety
that.
law.
No,
Okay.
I don't do that. This is a punishment. That's part of the punishment. And so I see it as a punishment. And that's why the legislature has increased, and they continue to increase these fines and fees. It's to say, don't do it again. Don't do it again. Don't do it again. And so, no, I'm denying that motion.
Yes, sir.
Can I make a couple phone calls?
That's up to the jail.
The questioning grows tighter, the responses get riskier, and suddenly the courtroom is hanging on every breath. It's the kind of exchange that reveals what people hope to hide, forcing the whole room to confront a detail that changes the entire trajectory of the argument.
Okay, Mr. Blocker, today's the date that's set for a hearing on a termination of tenancy, and my understanding is that the parties could not come to resolution. Is that accurate?
Okay.
Oh, okay, so you want to have a hearing today?
I want to file a motion, my motion right here, and I got it here. I need
File a motion for what?
a motion for collateral attack because I
The motion's denied. Are you ready for your hearing?
Yeah.
Okay, you can proceed.
Thank you, Judge. Plaintiff, please call Jenny Mrzinski.
Sorry. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
And you can have a seat there.
Mr. Mrzinski, can you please state your current occupation?
A property manager.
Okay. And are you property manager for the plaintiff?
Yes.
Are you familiar with the defendant, Corey Blocker?
Yes.
Could you please describe how you're familiar with the defendant?
He is a resident at South Washington Park Apartments. He resides in Unit 235. And we have filed a non-renewal tenancy for his occupancy there.
Okay. Could you please describe to the court why, first thing back, has the defendant violated the lease?
Yes.
Could you please describe to court how the defendant has violated the lease?
Since I have become manager of South Washington, which was in February of 2023, I believe there is 37 lease violations on file, ranging from quiet enjoyment to pets being unleashed, not picking up after pets, destruction of property, staff harassment, and on and on.
Could you please describe to court what Exhibit 1 is?
That is Mr. Blocker trying to kick in his neighbor's door.
On the very first page?
Yes.
How about page 2?
Page 2 is a letter he turned into the office where he threatened to beat up maintenance unless we told him he was stealing stuff out of his apartment. And he said that he would beat up anybody who was taking anything out of his unit.
object
What is their objection, sir?
because I this is why I asked for continuance, so I can bring in the proof that they've been breaking into my apartment, just like it's out there.
Okay, so your objection is not an evidentiary issue. Your objection is that you disagree.
I disagree.
Alright, guys, this is where the defense pushes back hard. The tone shifts, strategies clash, and every statement is thrown like a chess move that must land perfectly. You can feel the momentum pulling in two directions at once, as both sides fight to control the narrative. This isn't just testimony, it's a full-on attempt to reclaim the advantage in a tightening battle.
Okay, well then the objection is overruled because your objections are for evidentiary issues. You can object to evidence coming in because it violates a rule of evidence. This is not a violation that you're alleging. This is a dispute and you'll have a chance to give your own testimony. I'm not granting an adjournment because we had our first hearing. We've writted you here, meaning the government has paid for you to be here for today's court date. You were made aware of that at your last court date, which was back in November. This is now January that you would be having a hearing today. So you were to prepare yourself and have the court subpoena wherever you wanted to have subpoenaed here. You did not make those arrangements. Today's the date and time set to proceed with the hearing. So your objection is overruled. You can give that answer.
Can you please read the letter?
This is apartment 235. I ain't paying y'all shit, and if another thing comes up missing in my apartment, I am going to beat the maintenance dude until he tells me who's been in my apartment, and then beat the shit out of them, because I have a constitutional right to defend me and mine against any enemy, foreign or domestic. And then it's signed by Mr. Black.
And then page 3 of Exhibit 1 starts the lease violations.
Lease violations, yep, starting back in April. This one's April 3rd, 2023. You were seen by a staff member not having your dogs on a leash, not picking up feces. Please remember to always pick up after your dog and, have them on a leash.
So it starts on April 3rd, 2023,
Correct.
and the last one is July 11th, 2023. Is that correct?
Yes.
And at this time, can I ask
Yes.
this time, can Exhibit 1 be introduced in the evidence, admitted into evidence?
Any objection to Exhibit 1?
Yes, because like I said, when I sat up there and asked the apartment complex to sit up there and do anything to stop their neighbor from banging on my wall, I've got police reports. I asked you guys for a
Okay, but I'm asking you about these specific
because I'm telling you why the specific, because they wouldn't stop the next door neighbor from banging on my wall, slamming up stuff.
Thank you. The objection is overruled. The People's Exhibit 1, is it?
Yes.
That's admitted.
Have there been more lease violations after July of 2023?
Yes.
Can you please describe what else has happened?
Since July of 2023, we've been having a lot of quiet enjoyment issues and quiet enjoyment violations coming in. Mr. Blacker's neighbor and him, there has been a lot of complaints against Mr. Blacker as far as him making excessive amounts of noise, the door being kicked in. There's also a police report on file where Mr. Blacker actually punched his way through his apartment to the neighboring apartment. And there are pictures that I don't know if I got you, Jeff, but where he actually busted through his apartment into his neighboring apartment.
When he kicked in the neighbor's door, do you know if this was on video?
Yes.
Can you please describe to the court how the video cameras work at South Washington?
There are 101 cameras throughout the entire property, and we have security that monitors them, and they were called for the incident, reviewed it, and then sent us the video footage.
The pressure skyrockets here as contradictions surface and the courtroom locks into silence, waiting for the next move. It's a rare moment where uncertainty becomes almost visible. Every eyebrow raises, every note stops, and everyone senses the weight of what was just revealed. This is the turning point that shakes confidence on both sides.
Sorry, I'm still showing it. Now, Ms. Merzinski, can you please explain what happened in that scene?
Mr. Blacker was in front of 237's door kicking it, and then he walked back into his apartment.
And right here, he's kicking, is that his neighbor's door?
Yes, unit 237.
And then at some point, does he kick that open?
On that evening, no, he does not kick it open.
So, was this one of the lease violations for Mr. Blacker?
It was.
And I'm gonna stop sharing. And after that incident, where he was kicking at, or the defendant was kicking at the neighbor's door, was there another incident with the neighbor?
There was. That is when he punched through his apartment wall into the neighbor's apartment.
Okay. Yeah, can you please describe to court what Plaintiff's Exhibit 2 is?
First page is the actual lease violation on November 9th for him kicking his neighbor's door repetitively at 2:30 a.m. So that was November 9th was the door kicking, and then a week later was the door or the wall incident.
What is it that it's a report? Is that what that is? What is it? No, just tell me what it is.
Oh, I'm sorry. This is the lease violation of when he was kicking the door in.
Okay, so that's something that your office drafted? Or?
This is something that, yes, this was a lease violation
Okay.
that the office drafted.
Okay, and this was something that would have been provided to Mr. Blocker?
Yes, ma'am.
Okay, and how would it have been provided to him?
Mail and delivery on the floor.
Okay, thank you. Any objection to
I
that?
object, 'cause I never got this.
You're objecting that you never received
I
it?
never received that.
Okay, so again, that's a dispute. What you're saying, all the things you're telling me are okay for you to share. They're just not objections under the evidentiary rules. What you're saying is you dispute it, and I'm going to give you an opportunity to tell me your side at some point. So you save up all of those disputes so that you can make sure you address them then. But when I'm asking you if you object, what you're going to have to tell me is no objection, for example, that's not relevant evidence, or objection, that's hearsay. Those are the things that I'm asking you right now. It does not sound like you have an objection, so plaintiff's 2 is admitted. You, Mr. Blocker, you can question the witness if you like.
Did Mr. Blocker, when Mr. Blocker first moved into the apartment, did you guys send him 3 months of mail saying that he hadn't paid his rent, violating the statements that I sat up there and paid my rent? For 3 months, did you not send me notice saying that I hadn't paid rent?
I was not managing the property when he moved in.
So this is why I need a continuance, so I can prove my point. You guys are gonna sit up here and have me with no evidence to sit back and combat this stuff that they're sending.
How is that relevant?
How's it relevant?
How is that relevant to this issue? The issue that they are bringing you to court for is for termination of tenancy, not for non-payment of rent, and
because I'm showing where they sat back and violated the lease in the first place, because I sat back and paid the rent, was up on day rent, and they sat back and violated, sending me letters stating that I hadn't paid rent. Then I could sit back and go from like I asked you to sit back and have the camera work prove that I was there the day of the wall incident, begging them to do something to to the next door neighbor. I can also sit back and go and get my police reports to show that I sat back and I've had police reports that stated they were supposed to get the neighbor evicted. They never done.
The argument sharpens, the judge steps in, and everything feels like it's reaching a boiling point. You can see emotions push up against courtroom discipline as the tension threatens to crack the room in half. It's one of those sequences where every second counts and every reaction speaks louder than the testimony itself.
We got pictures we want to see.
Let's flush that out. Have you seen inside of his apartment?
Well,
that would say he went in my apartment.
Have you seen inside of his
I
apartment?
had to go inside his apartment when he tried to get to his neighbor, so I had to go through his apartment and seal the hole up in the wall.
So you saw the conditions of his property with your own eyes? Okay, so that's not hearsay, sir. So the objection is overruled. Any other questions?
No, Judge.
May this witness be excused from the stand?
Yes, Judge. Yes,
Thank you,
Judge.
Mr. Mills. Any other witnesses?
No, Judge.
Okay, are you gonna call any witnesses?
No, ma'am.
Do you want to give testimony yourself?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. Okay, you can proceed with your side.
Okay, so now the fact that I sat back and asked for literally camera work to prove that my apartment had been violated, broke in, just like my 3 dogs were took out without my permission to be taken out, that shows that.
When was your dog taken out?
My dog was taken out the night of the stated wall incident by animal control, and I never gave consent.
Okay, so you're saying animal control came and took custody of your animals, and this was in November?
November, yep.
Okay, and this was the night of the what incident?
This was the night of the stated wall incident, I guess.
Okay, so you did kick the wall in? Or punch the wall in?
No, I did not state that. I'm stating that this was this is when my dogs were took out. When I got took out of my apartment illegally. That's what I'm stating.
You got taken out of your apartment?
I got taken
by whom?
By the police, Atlantic.
Oh, you were arrested, sir. Is that what you're saying?
No, I was not arrested. I was took out of my apartment because a crime hadn't been proven committed.
Oh,
so
I didn't say you were convicted. That's when a crime is proven. Arrested is you're taken into lawful custody of the police department pending a conviction. So you were arrested by the police and removed from the property?
I was sitting up, like I said, took out of my apartment.
Okay, the police came to your property?
The police came to my property, yep.
Did they put handcuffs around you?
Yes, they did.
And they removed you from the property?
Yes, they did.
And that was in November?
That was whenever, November, yep.
Okay. And then animal control came that same day?
The night I had to have the judge from 30th Circuit to tell me that they came the night. They never
Okay, so you weren't there when animal control came, so you don't know who took the animals?
That's who got my dogs in their custody.
Oh, so
the judge from 30th
that's
Circuit.
Hearsay then, wouldn't it be? For you to tell me what you heard?
That's what
you just objected to someone else's hearsay. So I'm asking you what your personal knowledge is. You don't know what happened with the dogs then. Is that correct?
That's why I would need camera work that you're denying me.
I didn't deny. I don't have control over your camera work. I didn't deny you anything.
I sat up there and asked for a continuance so I could get the camera work.
You had over 30 days to seek that information.
I've been in jail for the whole 30 days.
Okay, you can make a request for evidence from jail.
I've made a request.
The same way you can file motions from jail.
And I did file motions, and I sat up there and filed the motion when the Congress gives you the authority to have me in here. None of my motions have been answered.
I don't have you in there, and I don't know what you're talking about when the Congress has give us the authority to get you in there. I don't know what you're pending, what you're in court for. It's not on this matter. It has nothing to do with this matter. You're here today for an eviction.
I'm here today because I've sat up here and all my rights have been violated because I asked for a notice. I asked for literally right to continuance, which I do have the right because I'm incarcerated. So I could go get the camera work to prove that my apartment had been broken in more than once.
He gave you a continuance in November.
You didn't give me a continuance.
Yes, we did.
You said continuance denied.
No, we set it out. We set it out more than 7 days for this matter to be for a hearing. That is what the law requires.
The law.
You have the right to have it set out 7 days. We set it out.
I do not have a right to have a continuance until after I get out of.
No, you don't have a right to continue until you get out of custody. No. What statute are you relying or law are you relying on that tells you that right? I'll wait.
Got him. Like I said, this is
okay. Any other testimony you want to provide?
Go ahead.
Okay. Argument, Mr. Klug.
Judge, Your Honor, the exhibits, the video show that defendant has repeatedly violated the lease even after the notice to quit was served. It continued, it got worse and worse. Plaintiffs requesting that a judgment be entered for possession only, and I believe the date is January 16th, 2024 for the writ.
Thank you.
Thank you.
Mr. Walker, you can make your argument as to why you do not believe you can be lawfully removed from the property.
I don't believe I can be lawfully removed from the property because, like I said, the lease was violated and broke before I had even had any complaints, any violations when they sat up there and stated that I missed 3 months of payments before I hadn't missed any payments. They violated the lease agreement before I did. So that's why I don't believe I should be able to be removed from the property because I sat up there and went to the apartment complex asking them to sit back and help me sit back and do the things that I needed to be done for the neighbors. So this would have never got there because I literally, that's why I asked for camera work to prove that I literally sat back the day of this whole thing, went and asked them, can y'all please do something about the neighbor? Please do something about it. And none of my requests were done, so they violated because they could have stopped all this. If they would have sat back, like I said, I could go get police reports, but I've been incarcerated. You're violating my due process that I should be able to show proof of evidence with the camera work, but I can't get to that if I'm incarcerated.
We're closing with a moment that ties the chaos together. The final statements land hard, the courtroom steadies itself, and the reality of everything said comes into full focus. It's the kind of ending that leaves you thinking long after the words fade, a reminder of how quickly truth and pressure can reshape a case. Thanks for watching. Don't forget to like the video and subscribe to the channel, and we'll see you in the next video.
As to the motion for collateral attack, again, the court has read your motion, Mr. Blocker. I'm going to first address your claims in the motion that there was a fraud committed or a violation of your Sixth Amendment right. Your right in a civil matter here in the state district court, because you seem to be heavily relying upon some federal rules, which were not in the federal court system. Your rules as it relates to when you can request a jury or demand a jury trial in a civil matter, which we advised you of those rights back on November 29th. So you were in the jail at the time. The court made a writ to get you on Zoom so that you can be advised of your rights at the time of a pretrial. On November 29th, we scheduled your trial on January 3rd. You had over a month at that point to hire counsel if that's what you wanted to do. You were advised of your rights to counsel. You were advised of your rights to have or demand a jury trial. The Michigan Court Rule 2.5089B clearly states a party may demand a trial by jury of an issue at which there is a right to trial by jury by filing a written demand for a jury trial within 28 days after filing of the answer or a timely reply. The demand for jury must be filed as a separate document. You did not do that. The jury fee provided by law must be paid at the time the demand is filed. You also failed to do that. The defendant failed to comply with court rules and failed to file a jury. I'm going to mute you because you're not going to disrupt me while I'm putting something on a clear record here. The defendant failed to comply with the court rule and failed to file a jury demand after filing the answer on a separate document and failed to pay the filing fee at the time of the demand. Therefore, the defendant's jury demand was not granted because it did not comport with the Michigan court rules. In addition, after your hearing or your trial that was on January 3rd, you then filed what the court responded to in a written order on February 20th, explaining why we denied your demand for jury trial because you didn't follow the court rules. You did have a trial, it was not by jury, and you had every right to be represented by an attorney. You appeared without an attorney after having been advised that you had the right to have an attorney, and you were advised of that back in November. You appeared January 3rd without an attorney. You demanded to have the case adjourned. The court rules does not require me to grant that demand to further delay an eviction when you were notified over 30 days in advance that it was going to be set for trial on that date. In addition to that, you knew well before November that you had a pending eviction happening because you had been served with that back in September. I don't have to let you get served with an eviction in September and then hold the case over until you work out your other legal matters and until it's at your convenience to appear in court. You have the right to hire an attorney because you do not have the right to court-appointed counsel in a landlord-tenant matter. You appeared in court, you were disruptive, you brought no evidence, even though you had every right to subpoena or have evidence subpoenaed and brought for you. You did not seek any of that evidence to be brought, and you did not properly prepare for a court. The same way you sat in jail and drafted all of these fine documents and motions that you filed, you could have drafted a subpoena or you could have drafted a request and sent that to Mr. Klug's office to get any evidence that you believe could have helped you support in your defense. The court reviewed the evidence, including a video that showed you kicking a neighbor's door in, and heard testimony evidence of other illegal activities and violations. I think there was almost 30 violations or more while you were in the property that you were residing in. And had you been represented by counsel, and even if you had some additional evidence that you could have presented at the time, the court would have still made the same determination that you had violated your lease and that you had engaged in unlawful activity that created an unreasonable risk of harm and a violation to other tenants' right to have a habitable unit. And so you still would have been evicted whether you had an attorney or not. You also falsely claim in your motion for collateral attack that Judge Simmons was acting under the color of law and in a personal capacity. Judge Simmons is acting in a judicial capacity and not a personal capacity. And for those reasons, your motion for collateral attack are denied, and your request for compensatory and punitive damages in the amount of $24,999.99 are also denied. As to the motion that you filed on the 17th, or at least it was received by the court on the 17th, for a motion for new trial under Rule 59 of the Federal Rules of Civil Procedure, are denied because this is not a federal court. We don't operate under the Federal Rules of Civil Procedure. This is a court under the state of Michigan. You file all your motions to comport with the Michigan court rules and rules of evidence. The courts read and determined that your motion is not only untimely because you were supposed to file any motions or any appeals within 21 days, you did file a motion to stay eviction and a petition to affix a defect, to which the court responded to back on February 20th, indicating why you would not get a motion to stay the eviction, and it's because you did not properly follow the court rules. You still are not properly following the court rules because you've been spending all of your time in the federal rules trying to figure out how you can skirt and navigate the system without being held accountable for violating your lease. Your eviction was finalized and your motions are denied.